Thank you, Honorable Chair. Mr. Pillay, good afternoon.
Good afternoon.
Yes. Yeah, I hope you had some time to reflect over lunchtime. Yeah, I'm a bit worried. You know, if you carry on like this, there's going to be two problems. One will be around finishing this cross-examination. The second one is that I'm going to argue at the end that your evidence should be disregarded because you are refusing to answer my questions, even the simple questions. So I think let's try, maybe after lunch, we'll make some more better progress. Okay? Yeah, I was saying to you, and I said I'm not going to move from this point because it's quite crucial for this whole entire process. This whole issue, the first issue that you and I dealt with, which is the status of judgments as opinions, but also this one now of where there are clear and blatant and patent errors in a judgment, which just at a factual level where one doesn't need to be a lawyer to pick up. These are going to be very, very monumental issues in this process. So I want us to work together. If let's go back, operator, to paragraph 113. Where we were before lunch. Yeah. So I'm saying, Mr. Pillay, this should be a simple exercise. What the judges said there, the public protector relies on this report despite explicitly stating that she has not seen the report. You and I have agreed that statement is wrong. Or at least, according to you, you've said something differently in relation to Mr. Van Lochenberg. Do you therefore agree that that's statement, do you disagree with that statement? Or do you agree with what it says? That in the public protector's report, there's anywhere where she explicitly or otherwise states that she has not seen the report?
Chair, I've gone on oath to talk about a coy denial. I do not mention explicitly. And the judgment states explicitly. And I'm sure, and I'm sure that the public protector will appeal that matter. That's
no. Thank you. That's true. But for now, the public protector is not the one on the stand, on the witness stand. I'm asking you, do you, on your knowledge, and since you have given a different version, do you agree that that statement is factually incorrect? Or do you say it's correct? It must be one of the two.
Chair, I would like to see when the matter comes to appeal, I would like to see the arguments advanced by the public protector.
No, it's not a legal issue, Mr. Pillay. It's not a legal issue at all. It's simple. It's eyes, you know. Whether she said she didn't see the report, any human being will be able to do that. Do you disagree with the version that in the IGR report, she said she had not seen the report? You could be a carpenter. That's just a simple question. It's got nothing to do with being a lawyer.
So I think she relied on the contents, and she said she had it on good authority.
Yes, no, we'll come to that. But let's. I'm saying, do you agree or disagree that there is nowhere in the report where she explicitly states that she has not seen the report? We'll come to the good authority.
Chair, that is possible. I can't remember what was said, but when we said at the time that it was a coy denial, we did not say it. She explicitly stated that she had the report.
Yes, you did not, because that would have been false.
Because we didn't know that.
No, but you had the report. What do you mean you didn't know that?
At that time, we did not know that she had the report. We believed she had the report.
Okay. Now that you've seen the report, do you agree or disagree that that statement is incorrect?
Possibly incorrect.
Possibly, only?
Yeah.
Yeah. All right. And then let's go to, and therefore then, if you go to 115, please, operator. Says, the charges now say, despite the fact that the public protector, according to the report, has never seen nor verified the contents of the findings of the IGI report, she ordered the Minister of State Security to implement it within 90 days. So that must also be incorrect, right?
Yeah, it may be incorrect.
Maybe. Okay, we'll get there slowly. Go at 116. Go to 116. The judges say, and you'll be happy to know this is the last one. It is difficult to understand on what basis these sections of the Constitution can notionally grant the public protector to grant, rather the power to rely on a report that she herself has not seen, because this is what she says in the report. So this must also maybe be incorrect, maybe.
It follows. It follows.
It follows, yeah. So if the other one is more than maybe incorrect, this one is also more than maybe incorrect.
Yes.
Thank you. All right. Well, there are many other examples, but I just wanted to deal with you with the one that involves you. Now, you would therefore agree that if a conclusion that is based on the wrong facts cannot be implemented, I mean, it's not, then it must be disregarded. In other words, if I say Mr. Pillay is in Australia, any other conclusion that follows from that will be wrong, because you are actually in Europe, aren't you?
Yes.
Thank you. And that would be the danger of swallowing line, hook, and sinker a judgment just because somebody typed words on a piece of paper. Correct?
That's sweeping generalization.
Okay, let's be. Okay, sorry.
Take one incident or one issue and say that the whole judge.
Yes, no, fair enough. But let's assume then this was the only issue in this judgment, was whether the public protector says she has seen the report. Then you would agree that then the judgment would be worthless.
No.
Even if it was just the only, let's say the only issue that was taken to court was simply whether or not the public protector says in the report that she has seen the report, and the judges got it wrong, as you and I have just discussed, would that judgment still be enforceable, or rather worth the paper that it was written on?
My understanding is that the public protector denied that she had the report. It's coyly denied that she had the report.
That may be so, yeah.
And when the matter goes to, if and when the matter goes to appeal, I imagine that aspects of a judgment may be adjusted. And that is up to the court there to make an evaluation of the whole judgment. Yes,
fair enough. No, but okay, that's fine. So, and if the court denies the opportunity to challenge the judgment?
And my understanding then is that the judgment is final.
Then that's it. Then it means even if you have the report and you can see that it doesn't match the what is said in these conclusions, that's it. She must just live with it for the rest of her life.
Chair, we're getting into into a speculation. I think the leave to appeal. You're going to appeal. Let us see what happens, and it might be that in the appeal that the judgments are adjusted.
Yeah, no. Okay, that's fine, Mr. Pillay. I'm just saying, I'm trying to talk to you not at the level of lawyers, just as a human being, person to person. If it happened to you, I'm just saying, let's say there was a judgment that said Mr. Pillay is a child molester. Sorry to use such a strong thing. And it was wrong. It's just factually wrong. You know that it's wrong. We all know it's wrong. I know it's wrong. You know it's wrong, and so on. I'm just saying, and then the court doesn't give you, let's say, the leave to appeal. What must you do? Can you then be removed? Let's say you are working at a school. Can you be removed as a teacher at that school on the basis of that clearly wrong finding that says Mr. Pillay is a child molester? When we all know, everybody in the country will agree that you are not, but it just happens to be typed in a judgment. Everyone will agree, but simply because it's typed in a judgment, you must then not be a teacher for the rest of your life. That's what I'm trying to say to you. Is that what must happen?
Chair, I believe I've answered many times.
Okay.
And my answer stands on that. If it's an analogy and one thing is found wrong, and everything else is still right, that puts a different complexion. If many things are found to be wrong, it puts a different complexion on things. Personally, I'm the last person to be unfair to the public protector. And in fact, the case I'm making is that the public protector has been unfair to me. She has consistently not listened. She has consistently accepted a particular version, unquestioningly. And that's the point I'm trying to make. I accept that people make mistakes, but I want to say this, that a person in authority, serious authority, there must be a higher bar on such a person to get it right.
Yeah,
that is my understanding. And the argument that this is a human being and she's going to get it wrong, I understand. But I think what I'm pointing out is that is a pattern. I'm saying that there's a pattern of behavior. It's up to the committee how they weigh all of these things.
Yeah, no, I understand that. And on the same vein, you would agree then that these paragraphs that I just sent you were also human mistakes on the part of those judges.
Oh, it's possible. People make mistakes.
Yeah,
they make mistakes, and one looks overall at how many mistakes are made, what types of mistakes are made. Is there a pattern? And then one announces.
Yeah, no, fair enough. No, that's why. Yeah, to be fair to the public protector, that's why she actually insisted that we should ask that there would be 3 judges in that case, because it was quite a complex case, just so that these what we call quality control issues don't arise. But no, I agree with you. People make mistakes, and if they do, even if they are so glaring and fatal on other people's careers, that's what happens. We're all human. Okay, no, that's fine. Now, If we can just want to. You accept then that the so-called rogue unit, one of the main issues there was the fact about the transgression of the intelligence laws of South Africa. In other words, most, if not all, of these people who found it to be illegal were saying so because it was performing functions which should be exclusively performed by the National Intelligence Agency, correct? We might have been wrong in that conclusion, but that was the gist of the illegality or criminality that was alleged against you, correct?
Yes, and confusing what was originally conceived and what finally happened.
Yes. If you go to operator, please, bundle E, page 817, item 1.1.
Can you repeat that for Tsepo?
Yeah, thank you, Chair. Bundle E, page 817, item 1.1.
Thank you.
Thank you, Chair.
Is that what you're looking for, Advocate Mpofu?
Yes.
Being flighted?
Yes, thank you. Just go down a little bit. Okay, that's the indictment against you as accused number 1 in the criminal case. Number 2 was Mr. Van Rensburg, as you say. And the number 3 was Johan Hendrik van Lochrenbeck. You remember this?
Yes.
Next. And it says the 3 of you are guilty of the following crimes, or are charged, let's put it that way, of the following: contravention of section 49(1) read with provision section 2, and so on, of the regulation of interception of communication and provisions of communication-related information act. That's you and Mr. Van Rensburg, accused number 1 and 2. Next one, contravention of section 10 of PRECA, Prevention and Combating of Corruption Activities, in that you unauthorized gratification by a party to an employment relationship. It's the one about what Ms. Bauer called the employment issue. And then contravention of PRECA as an alternative. And then just carry on. Okay, you can pass that. That one is about the SARS Act. I want to go to, the one about the NSI Act. Just carry on, please. Yeah. So this was about section 1 of the National Strategic Intelligence Act. It says that the established national intelligence structures as the Intelligence Division, South African Police, and the agency. What is being communicated there is that there are only 3 structures that have intelligence capability, and that you and Mr. Van Lochrenbeck and the others breached that law by establishing the rogue unit. Do you understand that?
That is what it says. We didn't establish a rogue unit. Go on.
Yeah. And just go to the last page, please. Very last page with the signature. Okay, that's signed by an advocate, JP Pretorius, SC, Acting Special Director of Public Prosecutions. Can you see that? And again, you say this is all made up.
I say that it is not true that the unit was founded unlawfully, number one, and number two, I say that we made representations to the NDPP, and the NDPP withdrew all of those charges.
Yes. No, but that's, you know, that NDPP withdrawing charges doesn't mean that you are not guilty. Just means that they might not have the witnesses that they need, but it doesn't really mean you didn't do it. You know that?
I know that the allegations also do not mean that I did it.
No, of course. But you also agree with me that it also doesn't mean you didn't do it.
It's possible, but what you are saying and what I'm saying.
No, but that's different. Me, I agreed with you fully. You are only going to go first to say it's possible, whatever that means. But that's fine. I'll take that as the best I can get. Okay, just go to the summary of facts, please, just after this. So this is how the National Director of Public Prosecutions saw the matter. And it says the accused persons, including you, were members of the Enforcement and Risk Division within SARS and were managed by accused number one, that's you, who was the general manager of the division of SARS. Accused one, you, reported to the Commissioner of SARS, and accused 2 and 3 reported to you. Accused 2 were employed officers and so on. Then 2, the Enforcement and Risk Division of SARS under the leadership of accused 1, Mr. Pillay, produced a memorandum which was signed by Mr. Pillay and Mr. van Rensburg in February 2007. The memorandum was directed to the then Finance Minister, Trevor Mkhwebane, and was requesting funding of intelligence capability within NEA in support of SARS. The purpose of the memo was to seek approval from the Minister to fund special capability within NEA to supply SARS and the law enforcement with the necessary information to address the illicit economy. Illicit economy refers to the importation of counterfeit goods, illegal harvesting of abalone, and smuggling of cigarettes, and the importation of transportation of drugs. The memo was recommended by the Commissioner of SARS, Pravin Gordhan, on 8 February and approved by Deputy Finance Minister Jabu Muleketi. The then Minister signed his approval request on 22 February 2007. The memo recognized that collecting tactical intelligence invariably meant that organized crime syndicates had to be penetrated to unearth their activities from within SARS, which was losing a lot of revenue. This was an activity for which SARS did not, at the time, have the capability, including the legislative mandate, to manage clandestine activity. Let me just pause there. You agree that that's what your memo said, that the intelligence, tactical intelligence capability that you were looking for was something that you were not entitled to do in law?
And that is why we wanted to do it with NEA.
Absolutely. Thank you very much. And that's where the problem is. You ended up doing it on your own.
That's an allegation.
Yes, it's an allegation, but I'll give you an opportunity to respond to it. Then it says, the memo also informed the minister that discussions were taking place with the National Intelligence Agency to supplement SARS intelligence capability. It further stated that NIA was willing to create a ring-fence capability provided that funds were made available to cover personnel costs. It indicated that NIA was willing to formalize these arrangements in an MOU and so on. So far, you agree that that's what you were requesting for the reasons stated, correct?
Right.
Then let's go to the last one, paragraph 4. In 2004, a member of the high-risk unit of SARS, with the assistance of accused number 2, commenced installation of equipment at the offices of the Directorate of Special Organizations and the National Prosecuting Authority. In September 2007, accused 2 instructed the meeting with the DSO that meetings of the DSO and the NPA should be monitored. This happened with the knowledge and approval of accused 1, that is you, Mr. Pillay. Both accused 1, Pillay, and 2 placed members of the high-risk investigating unit, that's the rogue unit, under the impression that the authorization required in Act 70 of 2002 was obtained from then President Mbeki. Various communications and meetings in the DSO were intercepted without the interception direction issued by the designated judge in terms of RICA. Conversations among members of the DSO during September 3rd, November 2007 were monitored, recorded, and transcribed without an authorization from the designated judge issued in terms of RICA. These recorded conversations among members of the DSO were handed to both accused number 1, that's you, Mr. Pillay, and 2 at their insistence. Accused 1, Pillay, even gave witness 13 an assurance, sorry, just want to check who's witness 13. That's Mr. Helgard Lombard. You know Mr. Helgard Lombard? Eh?
I do.
Yes. He worked with you in the so-called rogue unit. Oh, okay. I'll take that as a yes. Silence means consent. Okay. These recorded conversation among members of the DSO were handed both to accused number 1 and 2, rather. Accused 1 even gave witness 13 an assurance that if these interceptions were discovered, he, that is you now, Mr. Pillay, will take full responsibility for having given the necessary authorization and guaranteed the members involved legal assistance that will arise therefrom. So Mr. Lombard will say that, or rather said that you gave them the assurance that you take full responsibility and give them legal assistance. Do you take full responsibility for asking them to bug the NPA?
Through the chair. Chair, I did not ask anybody to bug the NPA, and these allegations are untested.
Right. Then it says, after the security and surveillance equipment were fitted at the office of the DSO, do you accept that at least there was spying equipment at the NPA, which was installed? Let's say not by you, but that, as a matter of fact, there was some.
And my understanding is that it was all done after hours.
I see. So by day, there were members of the so-called rogue unit, and by night, they were putting spying equipment at the NPA.
So,
and you are saying those two things were not related?
So the only rogue unit I know is the rogue unit of the SSA. So you're talking about the SARS unit?
Yes.
Yes.
No. Sorry. When I say rogue, so-called rogue unit, I know for it. Sorry, you call it the high-risk investigating unit. Yeah, I'm just calling it for what it is.
Yes. For what it is, the rogue unit is the SSA. So.
Right. Okay, then not that rogue unit. Your rogue unit.
No, I don't. Don't accept that it is the rogue unit. It has implications for lots of people who were members, people who did lots of good work, and it's unfair to tarnish everybody. Just as it is unfair to have broken a whole institution because of these allegations.
Yeah, well, that's true. Well, that's exactly, we feel the same about the public protector. It's unfair to break an institution in vain. But yeah.
Really compare. You really can't compare the two.
Well, you can't. Which one is better? The public protector or unit?
No, I don't mean in that sense. You can't compare the two analogies. We've been under the cosh for years now. And it still continues. And what the public protector is experiencing in our offices experience.
The Sunday picnic.
Yeah.
Right. Okay. Well, we'll see about that. Okay. Then after the secure. Okay. No. Sorry. We were at a point where you are saying that there were members of, let's just call it the unit. Let's use a neutral word. There were members of the unit who at night were bugging the NPA, or I'm sorry, supplying equipment, whatever you call it, to the NPA for spying.
No, no, that's not what I'm saying.
Okay, what are you saying?
I'm saying that there are people in SARS who provided a service to the DSO.
Right. But that doesn't make sense. Why would SARS provide service to the DSO? I mean, that's the NPA is
it was not a service provided by SARS as SARS. They approached individuals that they knew who happened to be working in SARS and knew that these people had experience in the provision of equipment, and it was for the purposes of the DSO.
I see. So and these people happen to be the members of the unit.
Yes.
Yeah. No, but they are saying the same thing. So effectively, what you are saying then is members of the so-called rogue unit or the high-risk investigating unit were asked, because they were known to be involved in this kind of thing, they were asked to provide this type of surveillance or spying equipment against our national prosecuting authority. I mean, isn't that almost treason?
That's not what I said.
Okay, what did you say?
I said that a private company provided those services to the DSO on the request of the DSO. That's what I said.
Okay. And was there a reason why this was done at night?
Because
by this company? Because
during the day they worked at SARS.
In a unit?
Yes.
Okay. All right. And then it says, yeah, after security surveillance equipment was featured at the offices of the DSO and NPA, an amount of 100,000 rand remained, and accused number 1, that is you, and 3, that's Mr. van Logenbeck, authorized the members of the high-risk investigating unit, otherwise known as the rogue unit, to keep the money as if it was a private installation. Oh, that's what you were saying just now. Thereby giving him gratification, which was not due to him. That is you. Accused number 3 also gave the member an authorization to perform private work after the work was completed in order to make the gratification to appear regular. This is almost like, it's what's called laundering or trying to ex post facto to justify this treasonable conduct. You understand the accusation. You may not agree with it.
We deny it. We deny that we were involved in anything unlawful. SARS was not involved in in the financial transaction. That was between members of the DSO and a private company. And I think I've answered this matter.
Yes. And just to try and save time, if you could just carry on, please. List of witnesses. So the witnesses was a range of witnesses ranging from the Commissioner for SARS to Mr. Vusi Pikoli, Advocate Menzi Simelane, just keep rolling. Just Elkhad Lombard, Dival, these are the members of the unit, correct?
What? Yes, but what does this have to do with the matter at hand?
Which matter at hand? Well, the matter at hand is the rogue unit, sir. Well, that's what we were discussing with Advocate Bauer. That's the one we're discussing now. Thank you. All right, can you keep rolling? Yeah. And Mr. Michael Piacha, do you know him?
I know of him, and I know him to be somebody involved in poaching, and we've
rhinos.
Yes, and we charged him from SARS. And I think after that, he began to work for the SSA for a while, and he also worked for cigarette companies.
Yes, but when he was doing rhino poaching is when he was a member of the unit.
Yes, and that is why he was discharged from SARS. And he
so they could bag NPA but not poach rhinos.
The NPA was not bugged. The NPA was assisted.
They couldn't assist the rhinos. Okay, no, that's fine. Let's keep on rolling. Then the next one is, okay, then we have Mr. Trevor Manuel. Those are the list of witnesses. Advocate Nell. Yeah, it's a who's who. But as you say, at some stage, the charges were withdrawn. And at least we've both agreed that means nothing. Whether it doesn't say you did it, it also doesn't say you didn't do it, correct?
Correct. It's just as the allegations mean nothing. Oh, yeah, please remove the list of people. Thank you. Thank you, Advocate Bauer. Right. Yeah, yes, no. I agree with him, Mr. Pillay. Yeah, they're just allegations. But at least we agree that the bugging did happen, but it was after hours, and it's not the bugging. It's not the words. I would not use the words bugging.
What words would you use about putting listening equipment in the NPA?
The NPA requested
to be bugged.
They requested equipment to be placed because they felt they needed it.
For what purpose?
And that's the question you've got to ask the NPA.
No, but you're the one who said you're going to get them lawyers if they get caught.
None of these things are tested. And in fact, the point made in the judgment is that the public protector didn't test any of these things.
Yeah, okay. Anyway, that's so much for the rogue unit. By the way, you are aware that the equipment of the rogue unit is now returned to the public protector, that Mr. Kisweta has invited the public protector to observe the handover.
I'm not aware, and again, as I say, it's not a rogue unit, and secondly, there's no equipment. There's no equipment. By the way, your favorite report, the Skakani report, says there's no equipment.
Also, to that extent, Skakani was correct.
Well, even he will happen to be correct on some occasions.
Yeah. Well, okay. Maybe we'll call him as a witness.
Please do.
Yeah, but we'll also call the members of the rogue unit if we have to. We're only speaking to one so far, but we'll inform the committee. Oh, well, excluding you and Mr. Van Lochenberg.
But really, the question is just, Mr. Chair, is why didn't the public protector do that work then? I think that's the issue.
She did. She spoke to Mr. Manyike, and she spoke to you. She spoke to many members of the rogue unit.
There's no affidavit from Mr. Manyike.
Well,
No
so
affidavit.
what? So what does that mean?
We made affidavits, and what we have put is evidence.
Yeah, she didn't use the same method to speak to members of the rogue unit. Maybe you were the lucky ones, but that's fine. Let's go to the retirement issue. We'll come back to this just so that I don't run out of time. Let's start with the matric. You have a matric certificate?
Yes.
Where is it?
I have it.
Where?
At my home.
Did you give it to the evidence leaders?
Evidence leader never asked for it.
Okay, and neither did the public protector ask for it? No.
She asked me if I had a matric. I confirmed. She asked me if that's what I told SARS I did. And if my memory serves me right, I did provide SARS at that time.
Yes. Yeah. No, she did ask for it, but in fairness to you, maybe she asked. She didn't ask you. Maybe she asked SARS. Yeah, but her evidence will be that she asked for it. Yeah, I'll find out just now. And by the way, I have no problem with your matric certificate. For the purposes of whatever I'm going to ask you, I'll assume that it exists. Yeah. But you see, the problem is that it's one of those issues. It's just a red herring. If we were not in a formal hearing, I would use a different description. It's really, just a deflection, maybe the most polite word. Because the point is, for now, let's assume they have a matric. The point was not whether they have a matric certificate or not. The point that the public protector, and you know this, was making was that somebody who only has a matric qualification under normal circumstances cannot be the commissioner of SARS. Surely, I know you might be what somebody described as an organic intellectual, but under ordinary circumstances, surely you'd agree with me, Mr. Pillay, that I'm not saying it's impossible, but it's unusual. Would you agree? I
agree. It's unusual to have a president like the one we had, but we came from unusual circumstances.
Yes, no, that's true. In fact, there are three examples. It's the former president and you and Mr. Hlaudi Motsoeneng. But the other two got to where they were because of political connections. How did you get there?
Hard work.
Okay, so you are even better than the others, because I think even they would accept that their ascension, unusual ascension, was politically driven, obviously in the case of the president, but yours was just pure hard work.
Mr. Chair, I think I must point out here, I didn't appoint myself.
Yeah.
I think these are questions you should ask the people that appointed me.
Yeah.
And what I do know is that we went through tough assessments during our period in SARS. Mm-hmm. We had something called the goodness of fit, which all of us, except the then commissioner, underwent. And I have the results of that goodness of fit assessment. And it was the result of a 4.5 days of assessments that were conducted. I have the results, and the results are available. If you want to see it, I will send it to you.
No, I believe you.
So,
But I'm just saying that at least we've agreed that it's unusual. It's something quite remarkable. I mean, taxation is a very complex subject. For you to rise to the top of our tax system in this sophisticated economy, armed with a matric certificate, is something remarkable. I'm saying I mean that, but I'm just saying that you would agree that it's not your usual occurrence, everyday occurrence.
Chair, I must point out again, these things happened after 1994.
Mm-hmm. No, even after 1994, I'm saying still unusual.
It's unusual, and I didn't enter SARS in a senior position. I entered in a mid-ranking position. I know somewhere it says chief of criminal investigations. I wasn't a chief. I was a general manager of criminal investigations, and I managed 300 people. And I worked in SARS for 15 years. So,
no, I'm sure there are many other matriculants who've worked there for 15 years or 20 years. I'm just saying they wouldn't rise up to becoming commissioner for SARS or acting commissioner for SARS.
Well, I think that there were circumstances to that. I didn't think I would be acting commissioner. Yeah. I had no wish to be acting commissioner. And by the way, when I was made a deputy commissioner, my first action was to actually refuse it.
Yes. Okay. No, that's fine. So let's leave the acting issue. Let's deal with the permanent position. You would agree that it's still unusual to be deputy commissioner of SARS with those credentials?
It is.
Thank you. No, that's fine. Now, you and Mr. Godan have been friends for almost 50 years, correct?
I wouldn't say we are friends.
What would you say?
We were fellow activists in Durban before I went into exile. Mm-hmm. I really did not know him well. I only met him on a handful of occasions. Mm-hmm. I then met him in the underground after 1977 on a few occasions inside South Africa, and then on a few occasions outside South Africa when he came through illegally into Swaziland. So it is we got to know each other better in the underground. I still wouldn't say that we are friends. We were comrades.
Yeah, well, friends can also be comrades, but that's fine. Let's. So you've just known him for all those years. You're saying you were involved in illegal activities.
In the ANC underground.
Yes.
Yes.
That's what I'm talking about.
Yeah. Yes.
So it was not the first time you were working clandestinely.
What are you referring to?
No, I mean now you and him agreed to form the rogue unit. It was not the first time that you were involved in clandestine activities.
No, I do not agree with that. And the conclusion that the unit was unlawful is not founded in law and in fact.
Okay, that's fine. Then, Mr. Godan and you, let's just say you were whatever comrades involved, and you've known each other for more than 40 years, just to be rough about it. Correct?
Correct.
And your evidence is that apart from the hard work, all that had nothing to do with your meteoric rise in SARS to be deputy SARS commissioner.
I really don't think so. As I I said to you when I was first told I'm in line for deputy commissioner, I did not, my inclination was not to accept it. And it's the reason why I've never stood in line to be commissioner.
Yes. No, I accept that, Mr. Pillay. I really do. I was asking you a different question. I'm saying, are you telling this committee and South Africans that your decades-long relationship with Mr. Gordhan had absolutely nothing to do with your miraculous rising to becoming Deputy SARS Commissioner armed with a matric certificate?
If you ask me, I would say I earned my place. We ran a world-class institution.
No,
and I'm not spinning words. By any measure of performance, we ran a world-class institution, and we cannot. If this is what happened, that people handed out in SARS senior positions to anybody who is not capable, SARS would not have performed at that level. It's impossible. It's impossible for performing organizations to be just appointing people that are not capable.
No.
It will show in performance.
Yes. No, Mr. Pillay, I think we're talking at cross purposes. I have no doubt about your performance capabilities. I'm sure they are superlative. I also have no doubt about the performance of SARS at the time when you were there. That's not what I'm asking you. I'm asking you whether you seriously say that anybody must believe that your miraculous rise to what you and I have agreed was unusual had nothing to do, whether you are capable or not is a separate matter, had nothing to do with your 40-year relationship with Mr. Gordhan. Yes or no?
Yeah, I would say it has nothing to do with it. And if anybody knows Mr. Gordhan,
I don't.
Yeah, the people that he drives the hardest are the people around him. And there's no easy road, there's no soft job that Mr. Gordhan gives to people.
Yeah, no, even that I'm prepared to accept.
So when there was an opening in SARS, I applied for it. I was assessed. I went for an assessment then. I was interviewed. I got the job. I wasn't on the executive of SARS when I joined SARS in the first few years. And so
fine.
that is my explanation.
No, Mr. Pillay, I accept that you are exceptional people. I mean, Mr. Gordhan was only a pharmacist as well, and you guys performed so well. Congratulations. But I'm simply saying, okay, I think you've heard what I've said. You haven't answered it. That's fine. Let's move on. Is it also your evidence that your so-called retirement had nothing to do with your relationship with Mr. Gordhan?
Yes, it has nothing to do with Mr. Gordhan.
I see. All right. So, but Mr. Gordhan, it is true that Mr. Gordhan, when this idea first saw the light of day, you wrote a memorandum, or rather a request to Mr. Symington, correct?
Correct.
That was in 2009, correct?
It should be, yeah.
And it was forwarded to Mr. Gordhan in March 2009, correct?
Correct.
And in that memorandum, you were requesting what I refer to as it is indicated in the judgment, you are requesting a package deal, for lack of a better word. In other words, that you should, quote unquote, retire, because we don't accept it as a retirement. Number one. Number two, that you should then be rehired immediately. And what was the third thing? That the SARS must pay for the money to the GEPF. That package, that's what you were requesting, correct?
Correct.
Right. Now, Mr. Gordhan was then told by Mr. Symington that that package was not a good idea if any element of it was not going to happen, you should withdraw the request, correct?
Correct. Well, I believe it was Mr. Symington who said to Mr. Gordhan, no, it's Mr. Symington who advised me that the three parts should go together, and if it wasn't agreed to, then I shouldn't proceed.
Yeah, okay. I don't think that's exactly how it happened, but that's nothing much turns on that. The point is that Mr. Symington's advice was that this scheme can only be advised if it was going to go as a package deal. But if one element was missing, it should be withdrawn, in a nutshell.
Yes.
Yeah. And because you see, once again, the judges in your judgment said that I was wrong to refer to it as a package deal, but that's a story for another day. So what then happened is that Mr. Gordhan became a minister after the 2009 elections, correct?
Correct.
A few months after you had given him this request, correct?
Correct.
And Mr. Mahashula became the commissioner for SARS.
Correct.
And then Mr. Mahashula wrote the request for your so-called retirement to the Minister of Finance, who happened to be Mr. Gordhan.
Yes.
Right? Correct?
Correct.
And Mr. Gordhan considered this carefully and approved your so-called retirement, correct?
Correct.
Again, nothing to do. Pardon?
Retirement from the pension fund.
No,
Just
retirement
repeat
from
that. I didn't get that. Just repeat that.
Sorry, Chair.
What I said is that I retired. My intention was to retire from the government pension fund.
Oh, I see.
Okay, thank you.
Okay, so why did you write to SARS? I thought you wanted to I'm sorry, Chair.
Just pause, Advocate Mpofu, Honorable Karen.
Sorry, while you were asking for clarity, I couldn't hear what that third part of the retirement package was.
Oh, okay.
Some funds, can we just have that clarified as well?
Yes, thank you, Honorable.
Just repeat, Mr. Pillay, again. In full.
Chair, I applied as part of that package to retire from the pension fund because I wanted to access my pension fund.
Sorry, just before that, Mr. Mpofu said that there were three components to the deal: retire, rehire, immediately, and then SARS to pay something, and I couldn't hear what it was.
Yes. Yes.
Was
SARS to
that
pay.
Advocate Mpofu or Mr. Pillay?
No, I can clarify it, Chair, if you don't mind.
Okay, please clarify it.
Thanks. Yes, Honorable Haran, this is very important. Yeah, it was what Mr. Pillay and I call a package. Yeah, had those two elements: retire, get the minister to agree for SARS to pay the penalty. There's a penalty if you retire before you reach the age 60. There's a penalty that is payable, and only with the approval of the minister that you fall under, in this case it would be Minister of Finance, can that approval be received for the employer to pay the penalty. So that was the second, or rather the third element, sorry. The second element, as I listed them, was that he would be rehired immediately. In other words, he would so-called retire, but be rehired immediately on a contract. Is that more or less it, Mr. Pillay?
Yes, it's on contract. Yes.
Yeah, thank you. All right. So, and just we'll come back to the sequence, but just so that Honorable Haran just has a complete picture. As it's actually happened, your so-called retirement happened at midnight on the 31st of December 2010, correct?
Correct.
You were rehired.
Just a pause, Advocate Mpofu, Advocate Bauer.
Just as a sorry, Advocate Mpofu, I'm not interrupting you.
Okay,
It's
no
discussed
problem.
at paragraphs. It's discussed at paragraphs 124 onwards. This package of the judgment.
Yes. Well,
Okay, proceed, Advocate Mpofu. Thank you.
Thank you. Except the judgment didn't said it was not a package, or rather something like that. But that's fine. That's true. What I was just saying, as a matter of fact, just to complete the picture for the honourable member and other members, the retirement, so-called, happened at midnight on the 31st of December, New Year's Eve, 31st December 2010, correct?
Correct.
Mr. Pillay?
Correct.
Yes. And you were rehired a minute later, 1 minute later, just as we were celebrating New Year's, 1 minute after 12 on New Year's Day, the 1st of January 2011, correct?
That's correct.
Thank you. Yeah, so that was the nature of the scheme. I call it a Ponzi scheme, yeah, but you might have a different word there.
Well, Chair, through the Chair, I should point out that all of these matters came before the courts, and the courts have applied themselves to it.
Yeah.
And
the court said it was okay.
The court said it was okay.
Yeah, I know. I was there. Yeah. Okay. But be that as it may, the committee will have to make its own mind on it. Yeah. Because you have raised it. I was saying it's not relevant. Yeah, but Ms. Bauer says it is. Yeah. So the scheme then. So effectively, the third element of the scheme is really what the public protector was worried about, namely that Minister Godan then approved that SARS must pay 1.1 million of the penalties to complete this scheme, correct?
Correct. I would prefer the package. It wasn't a scheme.
Yes. No, sorry. When I say scheme, I don't mean it negatively. Yeah, let's say package. Yeah. Without that approval by Mr. Godan, the package would have fallen flat. Correct.
I believe there were, yes, they would have fallen flat, and then there were other options which would apply.
Okay. And you said at some stage, or rather, when you were rehired in the same position of Deputy SARS Commissioner, correct?
In the role of Deputy Commissioner.
SARS, yes.
But I didn't have the same duties any longer that I had.
Yeah, but
prior.
you had the same title and the same money, correct?
Correct.
Yeah. And yet, you were, well, maybe let me ask you, because there are so many versions of this. What was the reason for you to be so lucky to get this package? By the way, do you know that there's no other South African human being has ever received such a package?
Chair, through you, I was told that 2,000 South Africans also accessed such. This matter has gone all the way, it's gone to the Constitutional Court, and the court has accepted that. The next thing I want to point out is that Commissioner Magashula pointed out, and I pointed out in my affidavit, that in the ordinary course of events over the next few years, SARS would have saved money, because SARS would no longer be contributing on a monthly basis to my pension. So that was submitted in an affidavit on the 21st of May, 2019. But of course, it was never responded to. And I don't think Mr. Magashula's affidavit in this respect was also responded to.
Yes. No. Okay. Be that as it may, I was asking you, what was the reason? Well, you say you don't know that, you think there are thousands of people who received a similar package.
Yes. We were told at the time when Commissioner Magashula discussed with the relevant public administration official that there were about 2,000 people who accessed
such a thing. Yes, actually, I think the number was 3,000. Yeah. It was said about 3,000, but it's a lie. There's no such thing. But anyway, we'll come to that. Yeah.
My reasons.
So there were about three. Sorry.
No, I was saying, Chair, Mr. Pillay was saying they were told at the time that there were about 2,000. I'm saying the actual number that they had was 3,000.
3,000.
Yes.
Okay.
But I was just saying that was just a phantom number. There's no other human being in this country who has ever received the package that Mr. Pillay, and I'll demonstrate it just now. Yeah. All right, Mr. Pillay, sorry. You in your affidavit, you cited 4 examples, not 3,000, correct? Including my friend, Mr. Geert Stevens.
I cited 4 examples from within SARS.
From within SARS?
Within SARS, all of them within SARS, of people who retired and were rehired.
Yeah, you see, that's where the misrepresentation was. So those people were retired and rehired, correct?
Correct. 1 minute past midnight. Yes.
No, that's exactly the point. Some of them had to be recalled when there was a shortage. Not they didn't retire and get rehired within 1 minute.
Well, I'm not sure about that.
Well, I'm sure.
I think
Okay, but if I'm right, then you'd understand that those examples, those 4 examples, should be thrown out of the window. In other words, it should not be comparing like for like.
well, I mean, what you're saying is that it would be okay if I pretended to be out of work for 3 months and then I was rehired.
Is that what you are accusing those people of doing?
No. That's what you're saying.
No. When did I say that? Maybe I forgot. I just, that's not what I'm saying. I'm saying those people were genuine, unlike you. They might have retired. Yes, you are right there. And then maybe 6 months later or a year later, SARS realizes that they might need their skills. They approach them and they negotiate a contract. Nothing wrong with that. I'm just saying none of them were the 1 minute specials like you. You are the only South African who has ever achieved such a feat.
Well,
and it probably will be for the next thousands of years. I don't think it will ever be allowed again, that kind of Ponzi scheme.
No, that's not a scheme, Mr. Chair. I object to that. The matter has gone all the way to the Constitutional Court, and the public protector has failed to prove otherwise.
Okay, objection is noted. Thank you.
Okay, thank you. Sorry for the scheme. Yeah. No, you cited in your affidavit, operator, if you can bring it up, it's okay. I don't know what I think it's all I know is that it's paragraph 25.6 of Mr. Van Pillay, Mr. Pillay's
25.6.
Yes, Chairperson.
Thank you.
Mr. Mpofu, can you tell us which affidavit?
The one he did in his case, or rather, when he intervened in Mr. Godin's case, the one that we've been dealing with, case number 36099. All right, while they're looking for it, Mr. Pillay, to save time, the persons you referred to, one was Mr. Trevor van Heerden, correct?
Correct.
Who had retired at SARS with 31st August 1999, correct?
Correct.
And later he was employed as a specialist in legal drafting, correct?
Correct.
No, certainly not a 1 minute special, correct? Correct?
I don't know what that means.
It means your situation where you were retired in 1 minute and were rehired the next minute or the next 2 seconds.
Chair, what I'm saying is that the intention, and it is explicit, was that I was retiring from the pension fund.
Or you're not retiring from SARS.
That was not the effect of it. But if one retired from the pension fund, then one retired from SARS, so one had to be rehired on contract.
Uh-huh.
That is the the rules.
I see. So it was a double return.
This was not a subterfuge. And by the way, this was well known in SARS. There was no attempt to keep any of this under wraps and to make it out to be a particular scheme. And I point out again that the matter has gone right to the Constitutional Court.
And the court says it's fine.
The court said you have not provided evidence to them to make a different view. They took a view. They made a judgment on what was placed before them.
Yes, Mr. Pillay. So what are you doing here? You came here knowing that there was a judgment on the matter. You came here to assist this committee to deal with this matter, correct?
Correct.
Thank you. All right. So you agree that Mr. Van Heerden was not a 1 minute special like you?
No, I resent that. Chair, I'd ask for your intervention.
Okay, I'll rephrase.
He's being insulting, and I don't think he should be allowed to do that.
1 minute is an insult. Did you retire at...
Your intention is to insult me.
No, Mr. Pillay. You are...
Advocate Mpofu, you were just giving a suggestion of rephrasing that. You can achieve the same thing with the rephrasing without... Thank you.
Mr. Pillay, you're the one who gives gratuitous insults according to the court. And that's why you were marked with attorney-client costs, but we'll come to that later. So, okay, let's go. I'm rephrasing. You agree that Mr. Van Heerden there was a period of more than 1 minute between him retiring and him being called back, correct?
I cannot remember that. You can tell me what was the period.
Is it possible that it was more than 1 minute?
I don't know.
All right. The next one was Mr. John Hansen. Remember him?
Yes, I remember Mr. Hansen.
He retired 31st December 1998 and was rehired 6 October 1999, almost a year later, not a minute later. Correct?
Correct. Chair, I think the Advocate Dali has made his point.
Yeah.
Whatever the point he wants to make.
No, fair enough. Okay, no, then we won't waste the time of the committee. The point I'm simply making is that the 4 examples, you even included Mr. Moyane, the 5 examples that you've given were not comparing like for like. And I think that's the point you're saying I've made, so we can move on, correct?
But Mr. Chair, is my affidavit here on trial? Is there an untruth that is there?
No, the untruth is what you've just told this committee, which is to say that these 4 people were comparable to your situation. No. So I'm trying to unpack that truth.
No.
And the court said it was fine, but I'm saying the committee will make up its own mind. That's the only untruth we're dealing with for now.
No.
Pardon?
So Mr. Gert Stevens was rehired. Just go up to Mr. Gert Stevens.
Yeah.
Go to Mr. Gert Stevens again.
Yeah, 25.6.4, yeah. He was rehired on the 1st of April 2003, having retired on the 31st March. Yeah.
Yes, what is that?
It's a 1 minute special.
So so how am I unique?
Okay, that's fine. So you agree that the others don't, the only one that is like you is Mr. Gert Stevens?
No, I don't. Mr. Chair, I don't know from the thousands of people who work in public administration in South Africa how many similar cases there were. We were told there were about 3,000. We asked for the records. we could never get the records.
No,
So I
Mr.
cannot pronounce on whether I am unique or not. I made a request. I did not approve this request myself.
Yes. No,
Mr. Opa
Mr.
Magashula made a recommendation.
Yes, Mr.
Bolan took his time. He finally approved that, and that is where I stand on the matter.
Okay, no, let me assist you. I'll even be on your side. Look at Mr. Kosi Low. Him and Mr. Claire Stevens are the same. 31st December 2013, 1st January 2014. The other one is 31st March 2003, 1 April 2003. So let's eliminate the other two. Do you agree that in the case of these two persons, at least these are the only two persons who are comparable to you in terms of the 1 minute number, correct?
Chair, from what is presented here, and we don't know that these are just the examples within SARS. These people were re-employed on contract day after they retired from the pension fund.
Yes, like you.
This is what this says. It says nothing about anybody else in government.
No, no, Mr. Pillay. This is your affidavit, right?
Yeah.
Yeah, you're the one who did this. So, and I'm not saying that it's talking about, you said, in fairness to you, retired, then continued to work for SARS after retirement. So yes, I agree with you. This is just SARS. Okay. Now I'm saying in these examples, you have two, but I'm saying to you, those two persons did not have their penalties paid by SARS, which is the real issue here. It's not so much that people retired. I'm agreeing with you. People might have retired, others might have been rehired, and as we have seen, some of them might have been even rehired immediately. But we're talking about the package here. Do you understand?
Mr. Chair, I understand that there is a package. I understand. I requested it was approved. I also understand that there was in this a saving to SARS over time.
That might well be, Mr. Pillay. I accept that. I'm saying there might be a saving. Well, no, I don't accept it. But for the purposes of my question, let's put that aside. That there might have been an eventual saving, but that saving would have been fortuitous, isn't it? It could have been a loss.
How is it going to be a loss?
Well, because they say, in pension law, there might be a saving that happens because the markets go a particular way or whatever. And that's not what I'm not discussing that. We'll come to that if you want to. I'm simply saying that the scheme at that time, or rather the package, cost SARS and the taxpayer 1.1 million rand. Agreed?
Agree, and this arrangement saved SARS money over the next few years.
Okay, so, well, I'm sure that thousands of South Africans would like to save SARS by getting a 1.1 million rand windfall. We'll come to that. Let's do it step by step. Yeah, I would like to save SARS as well if they can give me 1.1 million rand and a monthly pension payout on top of it. Yeah.
This is badgering. I've answered the question.
Sorry, what did you say to me?
This is badgering me.
I'm badgering you?
Yes.
How did I do that?
You're on the same thing over and over. I say, yes, there is a package. Yes, the penalty was paid. Yes, I retired from the pension fund. Yes, I was rehired on the day after. I say I didn't approve these things for myself. Right. You want to say it's a scheme? You say it's a scheme?
No, if I said that, I apologize. No, I'm not saying that.
That's fine, Mr. Pillay. That's fine, Mr. Pillay. Can we now proceed, Advocate Mpofu?
Okay. No, Mr. Pillay, yeah, I'm not badgering you, sir. I'm busy trying to cross-examine you. You volunteered to come here. I'm simply saying that I have to, it's my job, sir, to demonstrate that your evidence and your motives for coming here are not as holy as you want us to believe. That's just what I do. Yeah. So that's really my only intention. And I only asked you once about this issue of the 1.1 million. I don't know why you're saying I've kept on answering it. Maybe you are imagining it.
Mr. Chair, we've been on this for about 20 minutes.
On the 1.1 million?
On the package. We've been on it for about 20 minutes.
Yeah, no. Don't worry. We are on this. Yeah, you gave us a 500-page affidavit, Mr.
Yes.
Mr. Pillay, I think we have a set time for the process, so allow Advocate Mpofu to proceed with his time, because I think we'll be 30 minutes away from the time I set in the morning. Thank you.
We're very far from that. And anyway,
I'm saying at the time I set as a chair, which is 4
I see.
o'clock.
No, you did say we'll discuss.
Thank you. Thank you.
Right. I apologize, Chairperson. It's a Friday, you know. It looks like everyone is tired, including Mr. Pillay. But just be patient with us, Mr. Pillay. Okay, let's round it off. And in fact, in fairness to you, you tried earlier to say, the point is made, yeah. But then you said I must go look at Herr Stevens. You're the one who brought us back here.
No, because when you first put this, you said that I was unique.
Yes, but I was going through them one by one. You stopped me.
No, you stressed that the person 1 minute after. You stressed this. You called me a 1 minute special.
All right, Mr. Pillay.
Don't be untruthful.
Okay, Mr. Pillay. I'm not being untruthful. I've just demonstrated to you that you are unique because you are the only person who has all the 3 elements of the package. Do you understand that?
You say so. I haven't seen.
Okay. Do you know anyone else? All right. No, baby.
But you're not an authority on public administration.
How do you know that? How do you know that I'm not an authority on public administration? Who told you that? Do you just look at me and you know that I'm not an authority?
No, but all right. Then that means you've done the survey, you've checked all of this, and then if you tell me that this is unique, then I'll have to accept it because you're the authority.
Yes. No, Mr. Pillay, let's come down. I'm using your examples. You brought 4 names, correct?
Correct.
Yes. Now, it's not me, it's you. Now, I was saying, let's look at those names. And my intention is very simple. It is to support what I put to you up front, which is that there might be someone who retired, there might be someone who was rehired, there might be someone who, all these things, but I'm saying you, Mr. Ivan Pillay, are the only human being I know who had the package as defined. If there is someone else you know other than these 4, then you can tell us. Do you accept that?
Mr. Chair, I don't know, but my expectation is that since it is allowed for in the law, and by the way, because of where we come from, there's no way I'm going to know, by the way, what is allowed for in the pension laws and in SARS laws.
Mhm.
I asked to ask people, and people tell me. My assumption is that you can get, under certain conditions, the penalty paid, because this is what I was told. I'm not a person who sits and reads the laws and finds a loophole in the legislation. That's not my job.
No, Mr. Pillay, I think you are being unfair on yourself now. This is what, you don't have to read law books. Mr. Symington said this to you, that this thing, package, can only work if all the three elements are in. If one of them falls away, you must withdraw it. It was a simple 2-page memorandum. You don't need to read any law books. And this was explained to you after you had made the application. Am I correct?
Chair, my question is this. How would I even know that a penalty would be paid for me? Can be paid for me under certain circumstances?
Because you asked for it, Mr.
No, what I'm explaining is that it was my intention to go from the pension fund and to pay the penalty. Then I was told that, look, in certain circumstances, the penalty can be paid by SARS. Okay. I made the application. None of these things in law was designed by us. It's there. And I must finally point out is that I don't authorize I don't approve of this thing myself. I made a submission, and it was for Commissioner Magashula to say no, for the minister to say no. I would then reconsider what I'm going to do.
Yeah, but the point I'm making, the minister is not going to say no. He's your friend and comrade.
No.
And he's the one who originated this thing when he was a commissioner of SARS.
No, that is unfair. That's a slur on the minister. It's just, yeah, you're just throwing everything around now and hoping something sticks.
Mr. Pillay?
Yes.
Advocate Bauer?
You like insulting people, Mr. Pillay.
Advocate Bauer?
Mr. Chair, I want to bring to your attention that it's quite clear from the judgment that the payment of the 1.258 million came into effect by operation of law. It's not a factual question. And the reference to the judgment is 214 and 215.
No,
Thank you for the clarity.
Well, it's not clarity. That's not true.
Proceed, Advocate Mpofu, with your cross-examination.
Yeah, okay. Maybe Mr. Pillay will help us. Mr. Pillay, you accept that the payment of the 1.1 million would not have happened without the approval of Mr. Godan?
My understanding is that once the early retirement was accepted, the issue of the penalties kick in.
No, Mr. Pillay, please answer the question. Do you accept that the payment of the 1.1 million rand penalty would not have occurred without the permission of Mr. Godan?
In the end, he approved it.
Mr. Pillay, this is the last time.
Yes.
Do you accept or do you reject the fact that the payment of the 1.1 million rand by SARS would not have occurred without the permission of Mr. Godan?
My understanding is that Mr. Godan okayed my early retirement, and there was an automatic consequence. And indeed, he approved it.
Thank you.
You don't want to answer my question. That's fine. That's fine, Mr. There's nothing I can do. Yeah. Do you accept that when the package was presented to Mr. Godan, it was on the basis of the tripartite package deal that you would be rehired, the SARS would pay the penalty and you would quote unquote retire.
Yes.
Yes, and that's the uniqueness of the package. And did you say when you were applying for this that you were okay? No. Before let's let's kill this quickly now. You said that you were proposing to serve SARS in a different capacity, correct?
Correct.
But it turned out that you were rehired still as Deputy SARS Commissioner, correct?
No, the title that I had was the same. My role was different.
Yeah, Mr. Pillay.
I now headed the risk and enabling of SARS. Enforcement was moved out of me to Mr. Jean Ravet. So 3,000 people went to Jean Ravet.
All right, but you were still the Deputy SARS Commissioner, correct?
Yes, I was originally one of three, and the title remained with me. Eventually, I was the only one left.
So that was in the same capacity then. Your capacity was Deputy SARS Commissioner, correct?
Yes, it's the title. There was no particular authority that the Deputy Commissioner had.
No, I'm not talking about authorities, Mr. Pillay. You're going to say I'm badgering you, but you're just refusing to answer my question. Well, when you were rehired a minute after midnight on December 31, 2010, you retained the position of Deputy SARS. They say you were rehired in the same capacity, right?
In the same title, yes.
Pardon?
With the title Deputy Commissioner, whether I really don't understand in the same capacity, because the core of my work changed to enablement from enforcement operations to enable.
No, capacity is not my word, Mr. Pillay, it's yours. You said, I'm reading from a memorandum you wrote, on 27/11/2009, Dear OPA. And then you say, the purpose of the memorandum is to explain that I have decided to take early retirement, as well as to recommend the possible approval by the Minister of matters that flow from my decision. And then somewhere you said I was expected to perform at a high level. This exacted this toll from me in the sense of my health and so on. And then you say that should you favorably consider my proposal to serve SARS in a different capacity, so it's your word, such service will have to be subject that I be appointed as a contract employee. This will allow me more flexibility. The second condition will be that my early retirement is approved in terms of the provisions of Section 6A, meaning that the minister, in terms of the provisions of the above mentioned, shall approve the penalty imposed on my pension and so on. The GPF has indicated that the penalty amount my personal benefit to employer has to pay on my behalf is 1.2 million rand. That was the package. You proposed it on the basis that you should be in the same capacity, correct? Sorry, that's page 70, page 470, bundle E, item 1.1. Sorry, Chairperson.
I thought what you read was said it's in a different capacity.
Yes, you said in a different capacity, but I'm busy debating with you that you were then employed in the same capacity.
No, Chair, there is no, you look anywhere at the SARS, there's no special delegation for a deputy commissioner. There's no special salary band for a deputy commissioner. It is just a title. From the time that it was set up, it was never developed into anything. It's just a title. That's all. What really matters is what one did.
What are you saying? Are you saying that when you said to serve in a different capacity, you meant still as a deputy SARS commissioner?
No, you see, I didn't mean that.
So what did you mean?
This is so. In other words, the commissioner could have said, "Look, then you got to leave the title." I wasn't concerned about that. I was concerned that I wanted to move away from enforcement operations to the enabling space, which, by the way, is a recommendation that was made by our consultants that I should eventually move out of the operation space to the enablement space.
Okay, thanks. I don't think you even know what you're saying yourself, but it's clear that you said the work was stressful, it was affecting your health, and you would be prepared to serve in a different capacity. I mean, it's obvious. I don't know why you're running away from this.
That's what I said. I'm agreeing with you.
Oh, thank you. Sorry, it's my mistake.
I'm agreeing with you. I'm saying pay no attention to the title of Deputy Commissioner.
Anyway, what was the reason for you to get this win for this package? Or rather, to ask for it?
Oh, I had personal reasons to access my pension fund.
Yeah, but what were they?
They are personal reasons. They are medical and they are family related.
Okay, so at least in this memorandum, you said it was your health, correct?
Yeah, it's personal. Yeah.
And then at some stage it changed to something else, correct?
Yes, that's family. I think at some stage I spoke also about education.
Yes, it's kept on changing many times, but yes. So what was the real reason?
No, the broad overall description would be it's personal. It took toll on my health. It took a toll on the health of my family, and it as a family as a whole, we were making out decisions about how to move forward. So the
Mr.
reasons
Pillay,
are personal.
yes, thank you. Are you okay? Are you all right? You sound, you're slurring now. Are you just tired? Do you want us to take a short break?
No, I'm fine.
You're fine. Okay, we can carry on. No problem. No, I'm asking seriously. We can take a short break.
No.
No. Please proceed, Advocate Mpofu and Mr. Pillay.
We are going up to 4 o'clock. So
no, we're not going to 4 o'clock. We're going.
Please proceed.
Yeah.
Please
all right.
proceed.
So,
there are time.
Okay. So you no, Chair. I have to, if I feel that the witness is.
He is fine. He doesn't want to take a break.
Yeah. Well, you are not. You are no chairperson. You are not him. If he's not feeling well.
I'm the chairperson of this session.
Yeah, but it's my duty
He will say so if he needs it. Please proceed.
No, it's my professional duty if a witness is tired to ask him if he's all right, whether you like it or not.
Who is presiding over this session. It is not you.
Yeah, please. You're not a doctor.
Please proceed.
Thank you, Chairperson. All right. So, Mr. Pillay, if we go to, you know that Mr. Nick Coetzee said, Mr. Nick Coetzee said that this scheme, sorry, Mr. Pillay, that this package was not kosher, not all right.
I believe at the time, I didn't know that, but I believe he communicated with the commissioner and he pointed out certain things to the commissioner. He also later communicated with the minister to say there's nothing unlawful about it. So he had some misgivings about it. Yes. And he raised the question that If somebody else asks for such a thing, would you give it to them?
Yeah, no, okay, so let's go to...
But I only saw that afterwards.
No, fair enough. Yeah, in the court papers. Yeah. So let's go to bundle E, page 468, please. This is Mr. Kutsia saying that okay, please just work with me, operator. Yeah, I'm resending this email on account of a slight change I've made to the two attached documents. The changes indicate that the reason why Mr. Pillay is requesting approval for early retirement is to provide for his children's education. This was one of the versions of your request here. And not, as I have previously stated, that he wished to pursue other interests. You will now have to consider to recommend, and the minister considered to approve if this is sufficient reason. And you see that he puts that in block letters. In other words, the reason was important, okay? To recommend or approve Mr. Pillay's application for early retirement. If his application is duly approved, it could technically be construed that SARS is willing to contribute from its budget an amount of 340,000 towards the education of his children, right? Says, yeah, I admit this is a rather cynical viewpoint, but it can be a viewpoint that may be held by other parties as well, that may put yourself and the minister in a tight spot. You see that?
Yes.
Especially because Mr. Pillay was reappointed in his present position. The argument may be that he was able to continue with his present functions, but his early retirement and reappointment was purely to assist him to be able to provide for his children's education with 340,000 contribution, in quotes, from SARS. In other words, this whole package, as you call it, was just a free bursary for your children at the taxpayer's expense, according to Mr. Kutsia's analysis in this email, correct? Or rather could be viewed like that.
It could be, but there are also other views. Flock Symington had another view. David Makapela, SARS attorneys hired by the then Commissioner Tom Moyane, also said that the arrangement, the request and the approval was lawful. And again, I point out that all of these things went through all the court's processes right up to Constitutional Court.
Yes, but Mr. Flock Symington did not say that. It's a lie to say Mr. Flock Symington. Mr. Flock Symington only said, and the court found that you and Mr. Godan were misrepresenting what Mr. Flock Symington said. He only said...
The court didn't find that.
All right, I'll take you there. But the so-called, remember Mr. Godan said that he before he approved this, he took the advice of 6 people, including Mr. Symington, correct? Remember that?
Yes, I think I remember.
Yeah. So the court rejected that.
My understanding is what the court rejected is that these consultations had any bearing on the lawfulness of the action. In other words, showing that you've consulted A, B, C, D, E.
Yes. In other words, sorry, Mr.
No, I finished. I think I've made my point.
Yes. In other words, what the court said is that what you and Mr. Godan wanted the court to believe, that you had consulted so-called experts, was false.
No, but you see here that OPA consulted with Nick. Is that false?
Nick who?
The same Nick Kutsia that you were talking about.
No, Nick Kutsia was not even one of the 6. I just want to make sure. No, this is what this is what you and Mr. Godan said. The consultation of the so-called expert was said to have advised Mr. Godan, much cannot be really said about them if considered in the light of the argument by the public protector that the consultation process Mr. Godan seeks to rely on does not assist his case. Sorry, I can go to the judgment at paragraph 169, sorry. While you are waiting for that, Mr.
Paragraph 169, what page?
I don't know.
Now, how do we go there?
The same way we went there before, when we went to paragraph 95.
Sorry?
The same way we went there when we went to paragraph 95 just now.
Well, there was a page, sorry, we had a page then. Did you get it?
Thank you. All right, 169, thank you. Of the retirement judgment, the Pillay judgment, not the rogue unit. Yes. Remember, you and Mr. Godan wanted the court to believe that this was a very well considered decision. Even 6 experts and so on were consulted, and it was not some brusque thing. It was really like arm's length. But the court said this. Much cannot be really said about them if considered in light of the argument by the public protector that the consultation process Minister Godan seeks to rely on does not assist his case. Minister Godan's submission that he consulted with the best available experts with extensive experience in the retirement and pension environment when considered against the here under arguments of the public protector is not sustainable. Right? 1, firstly, the consultation with Mr. Symington took place some 17 months before Mr. Godan considered Mr. Pitt's request for early retirement. This is what the public protector pointed out. This public protector who must be impeached. She saw through that particular lie because you couldn't rely on something that happened 17 months before. So there is no indication that on record that Minister Godan consulted with Mr. Symington after I received Mr. Mahashule's memorandum. So that was the line number 1 from you and Mr. Godan. Then
No. I didn't lie. Don't say I've lied about anything. I haven't lied about anything.
Okay. Did you say in your affidavit at paragraph 10, no, actually 12, I associate myself fully with the detailed submissions of fact and law set out by Minister Godan in paragraphs 9 to 71 of his founding affidavit. Did you say that? Did you sign that?
Yes, I associate myself with that.
Yes.
But I was not there at the consultations to tell you what happened to it and when. I didn't lie about anything.
Yes, Mr. Pillay. But if you associated yourself fully, as you say, with this, and it turns out to be a lie, then you must suffer the consequences, I'm afraid.
No, but the consequences are that the judgment said in the end that arrangement was lawful. And your client failed to make her case. That's what the judgment said, and that stands.
Yeah. No, it didn't say it was lawful. Okay, I don't want to go legal. Do you know what a judicial review is? Do you know what is the difference between a review and an appeal, for example?
No, explain to me.
Nah, some other time, Mr. Pillay. So, okay, so the second line is this. I'm now at 169.2. Please, let's go back to the judgment. The court then says, secondly, Mr. Mkhwebane cannot be taken as an expert for the purposes of advice to Mr. Godhan, suppose, or rather, of the advice Mr. Godhan was looking for. Mr. Mkhwebane concedes as much in his affidavit to the public protector that he is not a lawyer and was acutely aware of the prescripts pertaining to the employee retirement. Thirdly, there is nothing presented to this court evidence when Mr. Donaldson, that was the other so-called expert, was consulted or what his advice was. And then they quote a case that we presented to the court about that legal advice must be presented on paper. So similarly, in this case, where it's motion proceedings, it was incumbent upon Mr. Godhan to set out exactly what advice he required and so on. As a result, we do not know the remit of their discussion. Next one, the other expert, so-called. Nothing contained in Mrs. Hendricks' affidavit amounts to independent legal advice by her or any other person relied on. So, next one. Fifthly, Mr. Godhan never had any direct contact with Mr. Govender. He also claimed to have consulted Mr. Govender falsely. That was also a lie. Fortunately, Mr. Govender gave an affidavit to the public protector and said he never spoke to Mr. Godhan, and to the extent that he spoke to Mr. Mkhwebane, no mention of a Mr. Pillay was ever mentioned to him. Anyway, okay. Why are you laughing? Is it funny?
Yes, because Mr. Chair, I must point out that it is not a lie to say that Mr. Godhan spoke to so-and-so, but that the judges believe that that person that Mr. Godhan is relying on, that advice is not of value for what the judges require. That doesn't make it a lie.
I agree. But when he says he relies on Mr. Govender that he has never had any direct contact with, as the judges say, is that the truth?
On that matter, I think when you get an opportunity, you must ask Mr. Godhan. But what I know is that both Mr. Godhan and Mr. Mkhwebane at different times spoke to Mr. Govender. I spoke to Mr. Govender myself, not in any detail, and he said he is talking to Mr. Mkhwebane.
Yes, but in his affidavit, Mr. Pillay, we're hearing that for the first time. In his affidavit, he says, yes, he had a discussion with Mr. Mkhwebane, but the name Pillay was never mentioned. He was asked about some broad principles about voluntary severance packages. That's fine. That's if you think that's the truth, that's your baby, between you and your God. Okay, the lastly, it says at 169.6. Lastly, in the conversation with Mr. Dan had with Mr. Oliver, that was supposed to be the last so-called expert, what we're privy of to is that they were discussing, among others, the importance of retaining the services of Mr. Pillay. Except for the retention of Mr. Pillay at SARS, this conversation would not have assisted Mr. Godhan about the early retirement of Mr. Pillay. So the court debunked any reliance on the so-called experts that you and Mr. Godhan relied on.
With your permission, can they read 170 also?
170. Yeah, well, I can. Having said that, it must be nevertheless borne in mind that Mr. Mkhwebane's memorandum is a submission made to Mr. Godhan by Mr. Mkhwebane as the Commissioner of SARS. It is not merely Mr. Pillay's application directly to Mr. Godhan. Mr. Pillay applied to Mr. Mkhwebane, and this memorandum to Minister Godhan was Mr. Mkhwebane submitting a memorandum to him, which he, Mr. Mkhwebane, asked and recommended for the approval sought by Mr. Pillay to be granted. So Mr. Pillay's application came to Minister Godan, recommendation of Mr. Makhashula as a commissioner. The ultimate employer responsible for the administration of SARS can be said that Mr. Pillay's application came to Mr. Godan with high recommendation and commendation. Yeah, that's why Mr. Makhashula was in the scheme. So how does that?
No, I think that's being very unfair to Mr. Makhashula.
Yeah, but that's why he was a respondent.
No, but you and again, there your client was unfair to Mr. Makhashula.
Yes, maybe that is so, Mr. Pillay. That's not what we're debating now. You asked me to read this paragraph. I'm telling you that all this paragraph does is to show that this was the Ponzi scheme had many members.
No, again, you're just smearing. You're trying to just throw your smears around.
Yes. Yeah. What are you going to do about it?
Well, it won't help you.
Yeah. All right. So I'm saying, Mr. Pillay.
Advocate Mpofu.
Yeah.
Advocate Mpofu. We now, the time now is 4 o'clock.
Yes,
and that's the time that I indicated to you 9 o'clock this morning. Yes, that we will end your cross-examination at 4.
Yes,
we are at that time now. I would like you to wrap up, please.
No, Chairperson, I can't. There's still a lot of material, but I'll try, Chairperson. But as I indicated in the morning, there's still.
I will give you the next 10 minutes to wrap up. Thank you.
No, I'm not going to finish in 10 minutes. There's a lot of evidence.
I will be finished with cross-examination at 4:10. So I'm allowing you to wrap up.
Hello, Chairperson, please listen to me. I'm saying to you that you might have in the morning thought about 4 o'clock. I didn't know that it's going to take me 10 questions to get one answer. Neither did you, by the way. So I know that
I am indicating that
you must take into account
your session at 4:10, Advocate Mpofu. Thank you.
It's fine. You'll stop me if you want to, but I'm not in control of how the witness answers. You know that. So you're just being unfair again, Chairperson. So let's, Mr. Pillay.
Yes.
Yes, we were at the point at which you had confirmed, at least, that, or rather, you asked me to read a paragraph. I wouldn't have read it if I knew that I was going to be curtailed like this. But now that I've made that mistake, I'm saying all this shows is that Mr. Makhashula, who wrote the letter to Mr. Godan, was part of the scheme.
Well, I just hope
you were still busy saying my client was unfair on Mr. Makhashula and so on. I'm saying to you that what happened, Mr. Pillay, and you know it, is that Mr. Makhashula wrote to Mr. Godan as if he was not part of this when he was a commissioner of SARS. Dear Minister, Mr. Pillay wants to retire. Can you also approve his contract that he must work here immediately and so on? The entire package. And of course, Mr. Godan signed it and said it's approved. But the things I'm putting to you are this, Mr. Pillay. One, this was an unprecedented move. It was costly to the taxpayer. It was motivated only by the fact that actually Mr. Godan should have recused himself from this, knowing that it had come. Basically, it was what in corruption language we call the javelin, where he, as commissioner of SARS, is now receiving his own request, so to speak, as minister later and approving it. That's just it's not done. But
what is the question, Mr. Chair? What is the question?
Listen, cool down. let me put the
No,
proposition.
I'm not angry. I'm just asking what is the question.
It's coming. Relax.
Yeah.
Okay? Take a deep breath and relax. The question will come. I'm putting to you that proposition that because of the fraudulent scheme and the corrupt and unethical...
Chair, I object to that.
But I thought you wanted me to finish.
No, I want you to finish, and I actually want you to finish right now. You can't just throw things around like that, and which you can't prove, which has gone to court, and which in court you fail to make the case.
Okay. Yeah,
Thank you, Mr. Pillay. Advocate Mpofu, the witness is raising an objection.
Well, I've never heard of such a thing, a witness raising an objection. But yeah,
You are hearing it
I've
now.
seen things here, yeah.
You are hearing it now.
Yes, that's what I'm saying.
That's it.
Congratulations to me. Yeah.
That's it.
Yeah. Now, Chairperson, please, why are you having me?
Asked. You're not being
What do you
harassed.
mean when
Please
you say that's
proceed with the few minutes that is left. Conclude your work. You're not being harassed.
No, you are
I'm
harassing me.
indicating
What
to
do you
you
mean
that
that's
the
it?
witness is uncomfortable with you, with the issues that you repeatedly are saying to him, and is raising an objection. And as a chair, I am noting and accepting that, and I'm referring to you to refrain from that.
Yeah, but don't say that's it to me. I'm not your little boy. So
You must
okay.
refrain from that.
Thank you. Okay. Thank you. Mr. Pillay, the reason why, please forgive me, the reason why I was packaging these things in a long series is because apparently I'm going to be stopped in the next few minutes. So that's the only reason. Otherwise, normally I'll break it down into small questions. Okay, let me put it this way. What we're going to argue at the end around these issues that I've canvassed you so far, before I get rudely stopped, is that firstly, you are aware that there were so many bases on which the public protector independently relied for the conclusion that the rogue unit was rogue. What is your comment?
The public protector did not make any independent check on any of those allegations. She swallowed them hook, line, and sinker, and that's not what a public protector should do. So that is not an excuse. In fact, that says a lot about her and how she does her work.
Yeah, no, save us the editorial, Mr. Pillay. Did she not give you an opportunity in terms of Section 7.9 to comment?
She did, but she paid no attention to it. And that's what the judgment found. She did not grapple with the evidence at all.
Did she not give Mr. Gordhan an opportunity in terms of Section 7.9?
The public protector goes through the motion. She does not she does not do those things in the required spirit. She doesn't deal with the evidence. The judgments go into some detail with that. She doesn't assess it. And on the other hand, when it comes to the allegations, she accepts it in toto.
Do you know that well, you should know because you were there, that she worked with investigators who did all this background work that you are talking about?
You're informing me, yes?
No, I'm not informing you. I'm asking you, when you were there, did you see other people? Maybe they didn't call them investigators, but did you see them?
Yes, I did see them.
Yes. And so you think all those people were just going through the motions? Why? Because what? They hate you.
No. I think that's not the issue. We know that these matters can be investigated, and I think, by the way, it is the public protector has got to explain why she didn't do these things. I don't have to give you a supposition on why she didn't do that.
Yes. Okay, that's the first proposition. The second proposition is that you, as the mastermind or the boss or whatever of the so-called rogue unit, were aware that that rogue unit was committing crimes, including treason, such as spying on the NPA.
I'll say again, the foundation of the unit was lawful. Insofar as its activities are concerned, the public protector didn't interview a single person from the unit. And in fact, on the equipment, which she was insisting it must be there because it's not there, she did not interview anybody on all of those things. There are no affidavits.
Yes.
And that is the point. And until these things are gone into, they remain mere allegations. And I deny that I was involved in unlawful activity.
Right. And I also will argue that from the evidence that you've given, it becomes clear that the only reason that you were elevated to such heights to Deputy SARS Commissioner was not because you are some particular whiz kid, but because of your kinship, comradeship, friendship, whatever you call it, with Mr. Godan.
That's actually absolutely not true.
Okay.
If you know Mr. Godan, you will know that it's not true. He's not a person who acts in that way. As far as I know, he's the hardest on the people that he has some.
That are his friends. Yeah.
No,
okay.
And I dispute that I'm his friend. It's not true.
Really? Okay.
Yeah, that's not true.
Then, yeah, I also put to you that the package that you and Mr. Godan, the unique package that you and him devised, at which he played for both sides as SARS and the Treasury, was a contrived scheme to rob the taxpayer of money and to give you free education on behalf of your children. And by the way, I know you deny that, but let me just, because we don't have time, but just point out what the 5 versions that were put up for why you entered into the package. You'll find that at page 979, item 1.1, bundle E, Chairperson. And
thank you, Advocate Mpofu. That's your last take.
Well, are you stopping me in the middle of a sentence?
No, when we conclude that, it will be the last take.
No, Chair. Okay, let me conclude this, then we'll talk, because otherwise I'll be wasting more of your time. This is what is said there, Mr. Pillay. Are they trying to find it? Okay, I'll read it to save time, Mr. Pillay.
Yeah.
It says that these are the versions given at different stages. The first one was wanting to fund the education of your children, as indicated in your initial memorandum of 25 August 2009, which you will find at page 13 of your application. The second version was to pursue, quote, other interests, as stated in 8th of October 2009 by Mr. Nick Kutsier, that you and I have discussed. You understand that?
Yes.
The third one is health reasons and wanting to serve in a different and less exhausting capacity, as indicated in your memorandum of 27 November 2009. That's the one we went through. You remember that?
Yes.
The fourth one was for personal reasons. That's the one you also said here. as indicated in the application for approval letter to Minister Godan on the 12th of August. Remember that?
Yes.
That's the letter of Mr. Makhashula to Mr. Godan. And then the fifth one was you needed to follow your wife and children to Holland, as stated by Mr. Makhashula in his affidavit to the public protector on 20th March 2019. You remember that version?
Well, that you say is Mr. Makhashula. That's what.
Yeah, but he got it from you. How did he know your children were in Holland?
Well, half my family did move to Holland. Yes.
It's when you moved to. Are you in Holland now?
Yeah.
Okay. Are you enjoying your retirement?
Not really. Not really, because
Okay. Yeah.
because the state capturers are still in pursuance.
Yes. And do you still get paid in respect of this retirement, so-called?
Yes.
Yes. And on that basis, then why did you go to court and want to escape on a technicality which you did? The court agreed with you, granted, that the matter is more than 2 years old, and therefore the public protector had no jurisdiction, which is what was found. When even today you are continuing to get the money, how can that be in the past when you are continuing to enjoy the money of the South African taxpayers?
That's a terrible.
Now, let me finish, Mr. Pillay. Yeah, how can that be something? Why do you and Mr. Godan have to hide behind that technicality, albeit that the court agreed with you?
Okay, so I'm hearing the words of a frustrated man. Again, who's just just throwing insults around.
I am frustrated. I'm being gagged.
Yeah. No. It's because all day you've been at this thing, and
you volunteered to come here, Mr. Pillay.
No, I volunteered.
You won't be here all day.
No. You must remember that the pension, I contribute to a pension, and the employer contributes to a pension.
Yeah.
And remember, I said that SARS has a saving. Mr. Makhashula said SARS will have a saving also. Mm-hmm. I deny that this is a scheme. And the very fact that you can find all of these things, all of these documents show there was no scheme in hiding all of these things. Everybody knew that I took this early retirement. So there's no attempt to hide any of these things. And I must point out again, you came with all of these things to court, and at every level in court. And as you point out, there were some arguments we lost, and there are some arguments you won, but overall, your client didn't make the case. And that is the issue.
And therefore, what? Should we stop the inquiry then? Because the client.
Thank you. Thank you, Mr. Pillay. Thank you, Advocate Mpofu.
Chairperson, for the record, sorry. Thank you.
Thank you.
Yeah. Okay, for the record, I'm not finished with the cross-examination.
Thank you, Advocate Mpofu, and you're well aware, together with evidence leaders, as I indicated in the morning, but further than that, the witness is available for today and not available at any other time. So I'm going to take a 10-minute break. We'll be back after 10 minutes.
When you say at any other time, you mean forever? Amen.
I did not say that.
I'm asking. Okay.
Thank you, and we'll be back after 10 minutes, and I will invite the members to engage with Mr. Pillay. Thank you. We'll pause for 10 minutes.
Thank you. See you later, Mr. Pillay.
Recording stopped.